This particular topic is entitled Medical and Legal Aspects of Pre-Hospital Care. As an EMS professional, you will be running into issues which may affect you in a legal sense on a daily basis. The idea here is to do everything you possibly can to protect yourself in the event that you're sued or in the event that something happens where you could be sued. The idea is to try and avoid being sued altogether. And I know I've given this lecture before many times in class, and I kind of come across as being somewhat of a grim reaper. So I just want to give you a disclaimer up front to let you know that we are really trying to just give you ideas of what might be out there. It isn't necessarily anything that's common. It's not necessarily common to be sued, but it is something that you most definitely will want to watch out for and try to take every step that you possibly can to make sure that you minimize your liability as much as possible. And one of the most important things that we discuss here is how you can really minimize your liability. Not just the liability for your department, not just the liability for your agency, but your own personal liability. Because after all, the entire goal of providing good patient care is to provide good patient care, of course, but also doing it without exposing yourself to any risks. So, what we're going to talk about today are three different types of responsibilities that you might have as an EMS provider. And these all kind of come together. Obviously, you have other responsibilities, but in this particular section, we're going to talk about the legal, ethical, and moral responsibilities and the differences between the three. We're also going to review the legal system very briefly, and then specific laws that are applicable to EMS, your accountability, what negligence and malpractice are, as well as specific EMT patient issues, operational issues, and documentation. So, legal versus ethical versus moral. What does that mean? Well, legal responsibilities are those responsibilities which we have to do according to the law. These could be particular guidelines that are established by regulatory agencies such as the Department of Health Services, if you have a Department of Health Services overseeing your EMS operations, or the EMS authority, or the county, or even the state. These are all legal responsibilities that you have as an EMS provider to do certain things during certain situations. Ethical standards, quite different. These are usually principles of conduct that a business or an organization or an agency or even your own agency might require out of you. An example would be, a dress code, or how you conduct yourself rather to your patients. You conduct yourself in a professional manner. The dress code would be part of being professional. The same thing would be, how do you conduct yourself with other employees? What kinds of things are permitted for you to do and say, and what kinds of things are not permitted for you to do? So these are all ethical standards. And there's different ethical standards for different professions. EMS professionals do have their own ethical standards, own code of ethics. You can look them up very easily by going into Google and typing it in. You'll see what our ethical standards are. Also, you'll have morality. Now, morality is quite a bit different. It is your individual sense of right and wrong. This is a very important thing, because you deal with life and death situations and critical issues on a fairly regular basis as an EMS provider, you will want to pay attention to yourself and your own sense of right and wrong, and make sure that you are adhering to what you should be adhering to within yourself every day. Because at the end of your career, when you go back to look on, when you go back and you look at things, you really want to be comfortable with what you've done the entire time that you were working. Now, granted, you're going to make mistakes over the years. Some people say they don't make mistakes, but everybody does make them. If you can do everything possible to make sure that you live up to your own morality, you will live a stress-free, or you'll have a life that's much more stress-free than most people at the end of your career. So just some things to think about there. Well, there's different laws that are affecting EMS. We'll go back to legality here. So we have scope of practice, we have federal, state, and local protocols and standards. So when we talk about federal protocols, usually we're talking about the national protocols that are recommended. Now we have the new national standards and guidelines models that have recently come out. These are some things that we look at as far as a national level to make sure that we're doing the things that we should be doing. These standards are then distributed out to the states, and then the states will generally base their standards off of what these federal guidelines are. The state scope of practice might be somewhat different from the federal scope of practice. It used to vary a lot more than it does now. There's a lot more uniformity across the United States than there used to be. There's a lot more uniformity throughout the entire world, for that matter. So you'll have different, again, state protocols and then local protocols. Now this could be, let's say, if you live in a large state like California, they break things down a little bit more. They have counties for each and every particular, county EMS authorities for every county, and the EMS authorities are responsible for regulating how things operate within their county. You also have standards and professional conduct that you should be adhering to. So those sorts of things might be established by your agency. Those are things that you'll have to follow. And they're not necessarily laws, but they are things that will be shown in court if you end up being questioned about what kinds of skills that you performed or what kind of treatments that you made for patients. If you're practicing beyond your scope, you really need to be careful, because you can get yourself into a lot of trouble. It also says here that you might encounter situations where hospital staff have requested that you transport patients who carry equipment or medication that you cannot. So let's say that they're asking you as an EMT, when you're doing a transport for a patient, to carry an intravenous line with a drip of nitroglycerin. If you're not authorized to do that, you should not be doing that. It says in the situations you should advise them you're not permitted to do so, and work with them in a cooperative manner if they request you wait until medications are finished or equipment is disconnected if permitted by protocol. Basically, we're trying to make sure that we are staying within the scope of our own practice, while at the same time being courteous and professional to hospital staff. The ability to practice, certification or licensure, again, these are the things that enable you to have the right to practice as an EMT. They enable you to have the right to do the things that you are permitted to do. This is your authorization. So it might be a certification or it could be a license. Just depends on your jurisdiction. There's a few laws that you're going to want to be aware of as an EMS provider. There are motor vehicle laws, and these motor vehicle laws are designed to protect you or tell you what you can and cannot do when you are driving to a call. When should you put your lights and sirens on, and when you should not? And if you do, what happens to you when you do and somebody gets hurt or injured? Generally speaking, you really want to make sure that you're looking out for everybody else's safety when you have your lights and sirens on. And it doesn't matter in many jurisdictions whether you get into a car accident or not while you're driving with your lights and sirens, because you can still be held responsible because you did not use due care or due regard to the people that you were asking to pull over while you were passing them. Or let's say you went through an intersection improperly and didn't clear it. You have a duty to act in an appropriate manner, and we'll talk a little bit more about negligence later, but the idea behind this is that you need to make sure that you know all of your laws and that you are not acting in a negligent or deficient manner. Infectious disease exposure also affects EMS. When you get exposed to a disease, you do have a right to go to the hospital as soon as possible and get yourself checked out. And you also have a right to have your employer pay for these medications. You can find out more information about how this works by going to the OSHA website. Also, assault against public safety officers, generally speaking, is considered an aggravated form of the crime, meaning that if the person does something like this, they can go to jail longer than if they had done it to another person. In the field, a lot of times people won't report this, or they'll get away with doing it because we deal with patients on a fairly consistent basis that aren't exactly happy that we're interacting with them and trying to help them. And unfortunately, it's just one of those sad facts, but just so you know, if these people get charged, a majority of states do consider it to be an aggravated form of assault, and they can go to jail for a longer period of time. There's also obstruction of duty. You might encounter situations where people may be trying to prevent you from providing care to people or that are sick and injured. Obviously, that's neither moral nor ethical nor legal in many states. You may encounter the situation more frequently with police department officers who might not necessarily be trying to restrict you from providing care, but may have their time or their attention focused on other things such as scene safety or providing security for the overall scene. So it's important that you establish a good working relationship with all of the people that you're working with, including the police department, so that you're able to work on scenes together. Good Samaritan laws. The question is, does it apply to you? Good Samaritan laws apply to everyone. The Good Samaritan law really depends on what this particular statute says. Generally, a Good Samaritan law will not protect a provider while they're on duty. It will protect providers that are off duty, but not on duty. And the reason is because when you are on duty, you have a duty to act. You have a responsibility to provide standard of care. And if you fail in providing that standard of care, you can be held responsible if the patient becomes injured as a result of the actions that you were negligent in. So, Good Samaritan laws generally more apply to those people who are off duty as EMS providers, or to non-EMS providers, non-medical personnel who just so happen to be at the scene and are trying to render aid. What is a Good Samaritan law? Basically, it is not a protection from being sued. Anybody can be sued for anything. It is a defense in court that you can use, saying that you acted in good faith to help the patient out or to help the person out, and that because you acted in good faith, you can't necessarily be held responsible as long as you didn't use like any invasive or crazy techniques to help the patient. You, as long as you're acting in a reasonable manner, as a reasonable person would be acting, you would be covered under the Good Samaritan law. Not all states have Good Samaritan laws, but a large majority of them do. Mandatory reporting. This is kind of a newer thing that's been coming out now. There have been many hospitals and EMS agencies that have gotten themselves into trouble across the country in recent years for not reporting certain things. I can think of one in particular where patients were being abused in the hospital and this information was not reported to the authorities. It was only reported up to the supervisors, and the supervisors reported this information up to the hospital administration. However, none of the information got to the police department, and because none of this information got to them, each of these hospital personnel were charged with this crime of not reporting this information. So it's very important you check and know your local laws so that you're reporting this information appropriately. All of this stuff right here. And again, I can read this for you, but these are the things that need to be reported to the police department. So when you're in doubt, you can just let the police department know and they can make a determination. You don't necessarily have to make a report for all these things. You just have to make contact with PD to let them know. Now on the flip side, it's very important for you also to let your supervisors know when it's appropriate, so that when somebody comes to them and asks them, hey, what happened with such and such, they had knowledge of what was occurring. You also need to make sure to protect your privacy rights of your patient, so make sure you're staying within all of those guidelines. Lots of things to remember, but you'll know this on a daily basis, what exactly you're supposed to do in these types of situations. But it's also not good, again, for a supervisor or management personnel to be blindsided by these kinds of reporting. So everybody should all be kept in the loop. Those who need to know should be provided with that information. And this information should be reported to the authorities. When we have accountability issues, now I know I'm going a little bit forward here, but I just want to see what we're going to cover. Okay, so accountability issues. We have standard of care, negligence, civil litigation specifics, patient civil rights breach, all this stuff, liability while you're off duty. All right, so I'm going to start here with a standard of care. Malpractice isn't necessarily a good term to use for EMS professionals. It's probably a better term to use for physicians, but the idea is relatively the same for us. What we really need to be looking at is negligence. And I'll actually start with negligence so that you guys can get an idea of how this works. So it's not in a confusing sense, but we can make this very clear. So negligence is comprised of four different elements. It is comprised of a duty, a breach of the duty, causing something to happen, and that thing that happens is an injury. So duty, breach, causation, and damages. That's the legal definition of what negligence is. So if we go to duty and we take a look at what duty is, duty means that was something that I was supposed to be doing. Like I was supposed to be doing a specific thing as a provider. And what this specific thing that I'm supposed to be doing is within my standard of care. That's my duty. My duty is to perform at the standard of care. The standard of care is the usually determined to be the national scope of practice. So whenever you're held accountable for something, it's more likely that people are going to be looking at you from a national scope of practice rather than in a state area or a local jurisdictional area. And this is just the way that the law works. It's not necessarily something that, you know, everybody would agree with, but that's just the way it is. So what's a standard of care? A standard of care, again, is what a reasonably, similarly trained EMT would do in that particular situation. Now, when we talk about breach of duty, the breach of duty is where I did something that I wasn't supposed to do. Now, just because I did something that I wasn't supposed to be doing does not necessarily mean that I can be sued. So, because there's other things that need to be proved here. It needs to be proved that I actually caused harm to the patient, that I proximately caused harm to the patient, and so these things need to be proven. Now I'll go over the differences between all these things very briefly. But breach of duty, to give you an example, would be like not doing your preventative maintenance on your vehicle, or it could be not checking the fluids at the start of your shift on your ambulance, or it could be not checking off the monitor batteries to make sure that they weren't empty in the morning. That's a breach of duty. Now, did anybody get injured as a result of that is another question, but that is simply a breach of duty. And you have actual cause and you have proximate cause. Now, we don't necessarily need to get into the precise legal definitions or differences between the two. The idea is that you basically caused the harm to the patient. So you were the cause of this issue, and that there weren't any prevailing intervening causes that made this incident happen. You know, let's say that somebody's claiming that you injured them, and it wasn't necessarily that you injured them. It was somebody else that came in and injured them before, and they thought it was you, but it actually wasn't. So these are things that can happen in the court of law. It gets a little bit complicated, but the idea is that you caused the harm. And the last thing that has to be proven in court is injury. Now, injury is not necessarily on here. It does say damage or harm, but it's injury. So the patient has to be injured. So if the patient's not injured and you did all of these things, there's no recovery for the patient. They can't get any money out of you or any money out of the department. So let's go ahead and I'll give you an example of a case that actually occurred a case that actually occurred fairly recently. And kind of having to do with the idea of spinal precautions, which is somewhat up for debate because we're all looking at SMR protocols right now. But the idea of this traditional spinal immobilization precautions case is you had a lady that was hiking up a mountain, and while she was on her way down, she fell and crashed horribly into the ground and injured her head, injured her spine, and it took the providers a really long time to get there. When they got to her, they put her in a scoop stretcher and rolled her down the mountain. Now, they rolled her down, obviously, with or they wheeled her down, rather. Didn't roll her down. But in any event, they wheeled her down the mountain. And she claimed that the providers injured her because she ended up being paralyzed. She was no longer able to walk after the incident. And the standard practice at that particular point in time was that the providers would put the patient on a backboard and they would wrap her up, do all the spinal precautions, follow all the methods that needed to be followed, and then put her in the stretcher and then take her down. And because she says that these people, these providers, breached their duty of putting her on the backboard and breached their duty of immobilizing her spine, she claims that she should be entitled to damages. Well, unfortunately, she was not able to prove causation because there was no way to prove that the providers caused injury to her spine. It could have happened before. It could have even happened after she was transported. There was no way to tell exactly when her injury happened. Now, I'm telling you the story because I'd like to illustrate the point that in order for you to be sued successfully and lose in court for these types of things, it's highly likely that they're going to need to prove injury. Proximate cause is also the most difficult to prove in most negligence cases involving EMTs. So, and not proving injury here, but they need to be able to prove proximate cause. Again, that's the most difficult to prove in negligence cases. You have civil cases, where the negligence case is also a civil case. So these are all civil cases that we're talking about. Res ispa locutor. The thing speaks for itself. This is the sort of thing that would happen where the burden of proof automatically switches to the defendant. Now, these are difficult things in a sense for you to get yourself into trouble with. This is more of a way for them just to say that because the patient was injured in the way that they were injured, it was automatically the defendant's fault or the provider's fault. And it's up to the provider to prove that they were not, negligent. So how does this work? Well, to give you an example here, let's suppose that you're in the back of the ambulance and all of a sudden the gurney hits the back of the doors and goes flying out with a patient in the back, and you're going down the highway at 60 miles an hour and the patient gets injured. Well, obviously that's the kind of thing that would speak for itself that it obviously was the ambulance provider's fault. And therefore, you would have to prove that you were not responsible for this patient getting injured. So, things that immediately come to mind are, were the doors locked? Why were the doors open? Why was it so easy for the patient to just, fall out? How come nobody was taking precautions to make sure that they were strapped in appropriately and secured, and the gurney secured in? So EMS or EMTs that work for public EMS agencies are often covered by sovereign immunity as well, which is something we need to discuss. What is sovereign immunity? Sovereign immunity basically means that if a person is working in an official governmental capacity, that they cannot individually be sued. So this is a good thing for you as a provider if you work for a state agency, because you can't necessarily be sued individually for the actions that you perform. Only the state can. In the sense of working for a private agency, it's a little bit different. Usually what will happen is the people that are suing the agency will go after everybody individually, and then also the company. And the company usually will take responsibility for all of their employees. However, it's not entirely required that they do so. So just something to think about. You do have a little bit more of a legal risk when you work for a private entity. Malpractice is a type of negligence case that's reserved for medical cases. We also have specific EMT patient-related issues. Consent, refusals, restraint, abandonment, transfer of care, advance directives, out of hospital, death. Okay, so all of these things right here. Just kind of briefly discuss the ones that are the most important. We're going to go through these individually, but I do want to discuss them with you, not too exhaustively. So when we talk about consent, we have informed consent. Informed consent occurs where the patient agrees to treatment after being advised of the possible risks and benefits. This is the type of consent that you should get from every patient that you deal with. Informed consent is always the best. Informed consent ensures that your patients are making the most appropriate decisions possible. Many times providers fail to give informed consent to their patients. So always make sure that you tell them what the benefits and risks are of all of the treatment that you are wanting to provide to them. Expressed consent is where they tell you they wanted it. Implied consent is where we can imply it. Mainly, a lot of times this can be done because the patient is not acting appropriately. We call it alert and oriented times 2 or less. So they only know person and place. They only know person and events. They don't know. They might not necessarily know all 4 of the alert and oriented questions, or they're just clearly disoriented. You can point to a whole bunch of factors as to why that's the case. Make sure you keep good documentation on this stuff. You also have involuntary consent. A lot of times this will happen through court order. And then minor consent, anybody who's 18 considered to consent to treatment. Anybody who's under 18, rather, is considered to consent to the treatment that's beneficial to them. So it's always best to try and involve adults who might be caring for minors, or try to get their parents involved. Remember that if a kid's at school, the school acts as their official or their quasi-guardian while they're at school. It is also important to try to attempt to make reasonable reasonably try to make notification to the parents. Um, Again, you might encounter some issues, where you could have some problems. Minors, we just kind of briefly discussed that. When in doubt with minors, really err on the side of treating them, because you can't go wrong with that. Unless, of course, there's some huge resistance issues, then obviously you're going to want to involve other people uh, to assist you. Apologize with that for that coming up. And then you also want to consider emancipated minors. What happens when a teen mother has a baby, or a pregnant teen, or a teen father with a baby? Well, these teenagers who are underage do have rights to their children and to their parenting, but everything else is fair game. So, even though you might have somebody who is able to make patient care decisions, or authorize you to treat, or authorize you to refuse, or they're authorized to refuse treatment. For their kids, they are not necessarily authorized to refuse treatment for themselves. This only applies to their relationship with their children. So technically, you could get into a situation where you might have to transport them unwillingly, because they don't necessarily have rights over themselves, but they have rights over their children. Kind of an odd legal situation there. It is important for you can also involve police department as a fail-safe, and that way at least you have them there. Then you have prisoners who, obviously they're beholden to the police department, or correctional facility, rather. Does the patient have legal and mental capacity, and do they understand the consequences, the risks and consequences associated with whatever it is that you're talking to them about? Consent issues might occur where you're having unlawful transport or physical restraint of the patient. And here we have assault, battery, false imprisonment, and kidnapping. Now, there's a difference between assault and battery. Assault is more like you're giving the person the feeling that they might be injured, rather than actually injuring them. And false imprisonment is where they are bounded into a restricted area and they're not permitted to move anywhere. Kidnapping is where they're bounded in a particular area and you're moving them somewhere. So how assault would happen would be where you didn't have consent to help them out, and you attempted to touch them, but then say they moved away very quickly, and again you did not have the authority or the privilege to do that, where say there would be involuntary consent. Battery is where you make actual physical contact with them, or something that they're touching. And then false imprisonment could occur where you were not preventing them or you're preventing them from going anywhere. And sometimes these sorts of things can happen during situations where the patient's being restrained. Kidnapping, obviously, this could occur where you're transporting the patient against their will and without privileged permission, which we talked about, these privileges. So if you have the privileges of the consent, then it's going to prevent you from being responsible for these 4 civil torts. Refusals. Refusals are so much of a problem for our field. We need to make sure that we always do refusals well. We have many problems and issues with them. So There is a right way to do them. There's consent for transport versus treatment, withdrawing consent. Obviously, the patient has the right to pick what they want to do and what they don't want to do. But in order for the patient to refuse, they have to have legal and mental capacity, be informed of the risk and benefits, and be offered alternatives. You should be having these issues documented and witnessed. Very, very important for you to do that. So let me talk a little bit more about refusals. Refusals are hands down the biggest liability that we have as EMS providers. Absolutely the biggest liability that we have. It is so important for us to make sure that whenever we are doing a refusal, that we do it properly. There are many problems out there where EMS providers will go through the documentation very cursory and just have the patient do a simple signature, not document things appropriately, and then they open themselves up to so much liability. Because if something happens to that patient, you can consider yourself responsible. In order to do a refusal properly, you need to make sure that you have done proper treatment for the patient up to the time that you do the refusal. So typically, if you encounter a situation where a patient just simply does not want to go to the hospital, you need to make sure that you have done the minimum amount of vital signs that you are supposed to do according to not only the minimum standards that are on your patient care report, but the standards that you should have as an EMS provider to take vital signs once every 15 minutes for stable patients and once every 5 minutes for unstable patients. So you need to make sure you do appropriate assessments. If patients refuse your assessments, you need to write refused assessment on your report, and you need to document the reasons why the patients stated that they were refusing. You also should be notating on your narrative the reasons why the patient wanted to refuse, your response to those reasons for their wanting to refuse, and their words after that. Because all of this stuff later on in court, if it's ever looked at, is going to be looked at as if it would be more heavily weighted in court, let's put it that way, than whatever you might have to say after the fact about the situation. So it's very important documentation because it's a legal record for you. In any event, once you make sure that you do that, do a full assessment if the patient will permit you to do so. If the patient won't, again, state that the patient won't on your patient care report, and then also the reasons why they won't let you do so. And then make sure that the patient reads the form part where it says that there's a refusal, and make sure you read then that information that's on there. And then also notate information on the front that you advise the patients of the risks and consequences associated with refusing treatment and transportation up to and including death, and they still refused. Now, a lot of providers have a problem with saying, if you tell the patient that they're gonna die, they're not going to be willing to or want to have anything to do with signing this document. And that's not necessarily true. What you should be doing is telling them this information because they have the right to be informed as a patient. Not only that, but it covers you in the event that something happens years down the road and you don't remember. Also, let's talk about who signs as a witness. You should always get witness signatures. Always. They shouldn't be your partner's witness signature, and it doesn't really help if it's other providers on scene. But there's a certain order of operations for witnesses. What you want to do is you want to have the patient's family members sign as witnesses that they refused your treatment, because this puts the patient and the family in a situation where it was obvious when you go back and look at the documentation that you really wanted to help the patient out, and therefore you told the patient and you told their family that they wanted to refuse, and they were there and they signed the document, and it just protects you from, like, liability if you do that. If you can't find or locate family members, have the patient's friends sign. Anybody who is partial to the patient will be received in your favor in the court of law. So again, family, friends, and then bystanders. So then you would have them sign, and if they can't sign, have somebody from a different agency sign, such as the police department, or somebody from an EMS agency if you're on the fire department. This will help to make sure it looks objective, and it makes sure that you actually are being objective. It just protects you further. It's all about minimizing your liability. This is how you do it. Now, it may be 2 o'clock in the morning and you choose not to do it, and you have your partner sign the refusal form. There's really no point in having your partner sign the refusal form, because everybody knows your partner was with you anyways. It's on the front of the run sheet. Does you no good at all whatsoever. It is very important for you to find other people to sign that witness statement, and make those statements just like I said to make them, and you'll protect yourself from getting sued successfully in court. If they're in custody or law enforcement, or in law enforcement correctional custody, you will want to make sure that you have the officer sign the refusal on the patient's behalf. This is because they have custody of the patient. If the patient is a danger to themselves or to others, make sure you involve PD, and possibly PD can, sign a refusal on their behalf. Again, you're going to want to inform the police department of the risks and consequences associated with refusing transportation, just like you would for a patient themselves. If there's caregivers that are on scene that have authority over the patient, this is the same type of situation as you might have with a guardian or a parent. Every single time that you do a refusal on a patient, you should call medical control. Always, every single time. And the reason why you should do that is to protect yourself from liability. Because now you've explained the situation to a medical professional, you've explained it to another medical professional rather, and they agree with you, or they have had the opportunity to listen to what you have reported to them, and they've decided that this does indicate or warrant the patient to have the right to refuse. Make sure you talk about what type of consent that you have from this patient, or excuse me, make sure you talk about what type of orientation that the patient has, what is their level of consciousness, are they answering questions appropriately, those sorts of things, have they had anything to drink. All of this stuff needs to be stated on the recorded line so that you have more information and documentation in your favor. Now, this stuff, if you become very good at it, is really only going to take you a few extra minutes to do. So, a lot of times people won't want to do this because they'll want to go back to the station at the end of the call and just be done with it. But I promise you that those extra 2 minutes are worth it, because you don't want to spend 6 to 9 months in court worrying about your job, worrying about your life and your livelihood and everything else and your certification, because you could have taken 2 minutes out of your time to do a refusal in an appropriate manner. always call medical control. Other issues you might encounter, patient abandonment. This means where you're providing care to somebody and you just leave. There are certain circumstances where you can leave a patient. You can leave a patient after you've transferred care. You can leave a patient when they refuse appropriately. You can leave patients when you're triaging them at a mass casualty incident. You can also leave the patient when there's a risk to your own personal safety. Now be careful with all of this stuff, because remember, you're also treated according to your standard of care. So if you're acting in a manner that's not appropriate according to your standards and guidelines, you can open yourself up to liability, you can open yourself up to risk. Transfer of care to the emergency department, and then also you might have issues where you're transporting the patient to their house. Again, you may have certain protocols that are developed for those specific types of situations. Make sure that whatever you do, you follow those protocols. Now let's switch gears a little bit. Let's talk about advanced directives. And you have DNR orders, do not resuscitate, living wills, and healthcare POAs. Now DNRs, let's see. Information about those is not necessarily contained in the slides. I'm kind of going through it, but DNRs are different depending on where you're at. But a do not resuscitate order basically means that the patient does not want any life-sustaining measures to happen in the event that they go into cardiac arrest. A DNR is not a do not treat document. It is a do not resuscitate document. So if a patient still has a pulse, or a patient still has a pulse and they're breathing, doesn't mean that you wait for them to die and then don't resuscitate them. You still have to provide care for them until they become pulseless and apneic. So make sure also when you're looking at these documents that they're according to how they need to be according to the law. You know, there may be specific criteria that are required for a DNR. It might need to be a specific color. There may need to be a picture. There may need to be a physician's signature. There may need to be specific instructions. There may need to be a whole bunch of things. Make sure you're familiar with what your state and local protocol is. The important thing here to remember is that when you look at a DNR, all of the forms should be filled out appropriately. If there are fields that are missing or blank, or there's not a picture attached and there's supposed to be a picture attached, or there's not a signature where there needs to be one, it is not a valid DNR. You cannot use it. Remember, if you're in doubt, call medical control while you're resuscitating the patient. Explain to the family the situation. If they disagree with you, tell them that you are concerned about the validity of the document. Advanced directives. So we have patient does not surrender their rights to receive medical care. Comfort measures are appropriate and provide the family support and guidance. Remember, they may be, although they have prepared for this moment for a lot of time, it still may be quite discomforting to them because it is a traumatic event to have to deal with. When in doubt, again, like I said, provide resuscitation measures and contact medical control. You can always contact medical control, explain to them the situation, and they can make the final determination for you at that point. It is better to err on the side of caution so that you prevent yourself from further liability in these types of situations. Out-of-hospital death is becoming more and more common. People are doing the end of life at home more now, and they've provided EMTs and paramedics with the ability to notify and recognize the signs of death. And this is where it's important for us to know that it may be in the patient's and the family's better interest that this happens. It just depends on the whole entire situation. But was there an initiation of care? There's things to think about for your documentation. Again, this is a medical legal section. So, were they doing CPR when you got on the scene? What were they doing with this patient? Was law enforcement there? If not, you need to make sure that they get there, especially for these types of incidents. Termination of efforts, resuscitative efforts, always requires medical control authorization. This means that if you were there, you touch the patient, you attempt to resuscitate them, or and the police department's not there at all, or any of those types of situations where you could be in doubt, you need to call medical control. In fact, you should always call medical control to make sure that they give you authorization to pronounce the patient. The survivors are now going to be your patients, obviously. So a lot of communities will have assistive programs, community outreach programs where they'll have counselors come and talk to the patients. Some of these services are very helpful. Whatever you do, make sure that you're always compassionate and caring for the people that you're providing care for. Remember, you're not always providing care just for the patient. You're providing care for the patient's family and friends who are there at that particular incident. Patient confidentiality is very important for us to remember. HIPAA, the Health Insurance Portability and Accountability Act of 1996, makes it so that medical information about a patient will not be shared with a third party without their consent, statute, or court order. So not all information is protected. Of course, infectious diseases need to be communicated to the appropriate places. One of the things we really have to watch out for here is defamation. And defamation is where there is a false statement about a person that's overheard by another person. And it only needs to be one other person. So this false statement can be made to your partner. It can be made to anybody. Remember, you want to avoid the situation. It could be this statement or false information could be in the form of slander or libel. Slander is in the verbal form and libel is in the written form. So where does libel occur, or where could libel be a problem for you? Well, it can be a problem for you on the patient care report. If you put false information on the patient care report and the patient care report is forwarded to another person, that other person looks at it and it's false and you can't prove that it was true, it is most likely going to be determined to be defamation. So it's always important to be careful here. Don't put any snide remarks for your patient care documentation. Always make sure you're careful with what you say about your patients. Operational issues. This is just kind of a whole slew of issues that could be that you could encounter. Obviously, there's a lot of them. You can have equipment failure, problems or interactions with law enforcement that might become an issue. Make sure you're always attentive to the preservation of any crime scenes. Also make sure that you follow your medical direction and you don't practice outside of your scope. Did you select the appropriate hospital when you took the patient there? Were you dispatched to the wrong address? What were the reasons for the delay in your call? Interfacility transports, risk management, vehicle operations, those sorts of things. Remember, there's a lot of legal issues that are facing EMTs. Ignorance is unacceptable. Know the law and know your policies. And that's it for this lecture.